One of the unfortunate parts of financing is foreclosure. Those things happen. I would hope when people take out a loan, they had every intention of paying off the loan. But sometimes things happen. Life happens. Get laid off, lose a job. Any number of things can happen and wind up not being able to make your house payment. And if you can't make your payment, then obviously the lender wants their money back. And if you can't pay it back, then they're probably going to want to take the property back so they can sell it and try to recoup their investment that way. But when it comes to foreclosure, again, this is going to work differently. The process of foreclosure will work differently, again, depending on the state that you live in. We talked about whether you're in a lien theory state or a title theory state, whether you're using a mortgage or a deed of trust. All of those kind of play into what type of foreclosure action will be necessary if we get to that point where the borrower just can't make their payments. So what we're going to look at right now are a few different types of foreclosure. We're not going to get deep into any of these, but you just need to be familiar of the different types of foreclosure. One type is a judicial foreclosure. That means you're going to court. Now, why would we have to go to court? Well, if you have a mortgage, and typically if you're in a lien theory state, you're probably going to lack this, what they call a power of sale clause. I'll talk about that here in a little bit, but so the lender does not just have the right to take the property and sell it without some kind of judicial overview here. In effect, they would have to file a lawsuit, in court, to get title to the property, right? Because in a lien theory state, remember, the borrower gets not only equitable title, the right to use the property, but they also get legal title at closing. So before the lender can take any action, they have to have title to the property. So they'll have to file what they call a judicial foreclosure. Means we got to go through the court system to get title to the property. And then once they get title to the property, if they need to, then they can have the owner put out of the house, evicted or whatnot. But basically, judicial foreclosure means we have to settle this issue through the courts. Now, we were talking about this power of sale clause, and this would be something written into the mortgage or that deed of trust, which honestly probably would be more applicable to the deed of trust, which you would see most often in your title theory states. Because if you recall, in a title theory state, if you're the borrower, all you get is the equitable title, right? The right to use the property, but you do not get legal title because that's been held in trust. And typically when you have that situation, that's where this power of sale clause exists, which would give the lender the right to just go ahead and sell the property because now they have title in the trust. So with the power of sale, we could avoid having to deal with the court system, which is the next foreclosure procedure, and that would be the non-judicial foreclosure, meaning we're not having to go through the court system, but because in that deed of trust, it has that power of sale clause, and with the power of sale clause, they can just go ahead and sell the property because they already have title. We don't have to go to court to get title. They already have it through this deed of trust. So that'd be the non-judicial process. But then there's something called a strict foreclosure where basically the lender will give you some period of time in order to pay off the debt. They're trying to work with you. So they'll give you some period of time to pay off that debt. And if you cannot pay off the debt, then title will be given to the mortgagee free of any rights of the mortgagor. Remember, the mortgagee is the lender, right? So you're agreeing to just, if you can't pay this off within whatever time period was agreed upon, then title will go to the lender, the mortgagee, and then they could go ahead and sell the property and get their money back that way. But as a strict foreclosure. We could have a deed in lieu of foreclosure. This is where basically the owner can say, you know what, here's the title. I'll give you the title to the property if you'll grant me relief from the debt, because obviously you can't pay it. So what the lender would be hoping for, the mortgagee, is if they still owe more than what the borrower has paid, there's still a balance on the loan, then what their hopes are, they can take the house, sell it, and get whatever still owed to them out of the sale of the property. But that's called deed in lieu of foreclosure. And I would just if I could throw my opinion out there, obviously this would be a terrible situation for anybody if they're going through foreclosure. But at the end of the day, if you can't make that your payment, whatever the reason is, if you cannot make the payment, doesn't it make sense that you're not staying here? You're going to leave one way or the other. And I will tell you, the more you work with the lender, instead of forcing them to go through a judicial foreclosure, having to go to court, I'm telling you, there's some things the lender could do that will help you down the road. Depending on how this was resolved, could have a significant impact on your credit for years to come. Okay, I can tell you, if we got to go through the court system and you're being that hard to get along with, they're probably going to make sure you don't get another loan anytime soon. That's for sure. So those are some of the types of foreclosure. Now, the next thing we need to look at here is something called a redemption period. Assuming you're being foreclosed upon, or the lender has already executed their foreclosure process. There's two there's two redemption periods you need to be familiar with. And again, depending on the state you live in, will have a lot to do with which one or which ones you may have a right to. But the first redemption period is the equity of redemption. And by the way, when we talk about redemption period, that's some period of time that you could come in, pay off everything you owe, and keep or get the property back potentially. So your equity of redemption period, that's the time from the moment they initiate foreclosure action right up until right before they sell the property at foreclosure sale. That's your equity of redemption period. That's the time you have to come and pay everything off and redeem or keep the property. But then you also, depending on the state you live in, again, you could get this right of redemption. And this is the period of time from the moment they actually sell the property at foreclosure right up, actually you got 1 year from the time they actually sell the property to claim your right of redemption. So everybody's going to get the equity of redemption. That's again from the time they initiate foreclosure up until the foreclosure sale. Some states will allow the right of redemption, which is the time from once they sell it, you've got up to 1 year after the foreclosure sale. For what it's worth, I'm in South Carolina, and in South Carolina, right of redemption is not allowed. So once the property is sold at foreclosure here, then it's it. The property's gone. You cannot redeem or get it back. But again, that's going to depend on the state you live in on whether you get the right of redemption or not. Now, the last thing you see here, is talking about deficiency judgments. This is where people really make bad mistakes, typically. Y'all, normally, if you're taking care of the property and maintaining the property, there are some exceptions, but typically, if they have to sell the property at foreclosure, they should be able to sell it for enough to at least pay off what you owe and maybe hopefully even some more. But if you go in there and tear that property up, steal fixtures out of it because you're mad at the lender and you're trying to get back at the lender, and this is a very bad emotional decision you'd be making right here. You better hope that it can sell for as much as they can sell it for if they're going to take it, okay? Because what's going to happen, let's say they sell the property and there's still $50,000, $75,000 that's still owed. They couldn't sell it for enough to pay off everything you still owe because you destroyed the property. It's in such bad condition, hadn't been maintained, whatever the situation is. Well, you're still going to be responsible for that money, okay? So the lender will file a deficiency judgment because you didn't pay off, there wasn't enough in the house to pay off the loan. So basically you're going to go to court over this, and the courts will require you to pay that debt, whatever that additional amount is. And if you can't or don't pay it, then this is what becomes a deficiency judgment. A deficiency judgment is considered a general lien. And if you recall several chapters back, we talked about types of liens. Remember, we said a general lien means that creditor can now come and take everything you own, both real property, if you happen to own any other real estate, but also, excuse me, but also personal property, your car if you got one. They're going to take everything you own to satisfy this debt. So in essence, with a deficiency judgment against you, until you pay that off, you'll never own anything again the rest of your life. That's terrible. All because of we let our emotions, typically, we let our emotions make some pretty bad decisions, and that's the result of it. But that's the different types and some of the process of the foreclosure action. Hopefully that helps you a little bit.